Hi everybody, Taylor Mathis here, the KEYTLaw girl, marketing director and legal assistant at KEYTLaw. Today I'm going to go over something that we get asked about a ton at KEYTLaw, and that is, should I form my LLC in Nevada instead of Arizona? I'm going to get to that in a second, but first, throw this video a quick like, comment if you have a question, and be sure to subscribe to our channel for more videos like this one. We upload new content every week to assist with your legal needs. So many people frequently ask if they should form their corporation or LLC in Nevada instead of Arizona. When asked why they want to form a company in Nevada, they usually say to save state income taxes or to hide the fact that they own the company. So they're trying to be stealthy. But our typical response at KEYTLaw is whoever told them that is either one, misinformed, so we're trying to give the Nevada law expert the benefit of the doubt, or two, they're not the sharpest tool in the shed, three, they're intentionally trying to deceive and sell their Nevada ultimate asset protection entity product, or four, simply all of the above. Some people also say they want to form their entity in Nevada because Nevada has the best entity laws of any state, and Nevada has the Series LLC. So let's look at each of the reasons people claim they want to form their corporation or LLC in Nevada. Reason one, to save taxes. Forming an entity in Nevada will only allow you to avoid income taxes only if all of the revenue of the entity is derived in Nevada or states that don't have income taxes. The law of the United States is that if an LLC or a corporation formed in state number one has a presence in state number two that has a state income tax, and if the LLC or corporation derives income from within state number two, then state number two can tax all income derived within its borders. Thus, a Nevada LLC or corporation that operates a retail store in Arizona must report and pay Arizona state income tax on the income derived from the Arizona business. So reason two, to hide ownership. The California Court of Appeals in the well-known case of Associated Vendors, Inc. versus Oakland Meat Company, Inc. of 1962 listed facts that should be analyzed in determining if an alter ego situation exists. The corporate veil should be pierced and hold the shareholders liable for the debts of the corporation. One of the 19 negative facts the court listed is the concealment of misrepresentation of the identity of the responsible ownership, management, and financial interests, or concealment of personal business activities. So if you hide your ownership of your entity and you end up in court, you will have some explaining to do to the judge or jury as to the purpose of why you hid the ownership of the company. Reason number three, Nevada laws are the best. Well, says who? The person trying to sell you the Nevada entity? Asset protection attorney Jay Atkinson says Nevada laws are not substantially better than the laws of any other state. Randall K. Edwards, an asset protection lawyer and litigator who has been licensed to practice law in Nevada since 1983, agrees with Jay Atkins that Nevada entity law is no better than entity laws in any other states. Randall says, I rarely recommend to any of my clients that they utilize Nevada entities unless they have some connection to Nevada. That statement is from an attorney who is licensed in Nevada who forms Nevada entities. If you also look at the 2008 State Liability Systems Ranking study prepared by the U.S. Chamber Institute for Legal Reform, they ranked Nevada as the 40th in a nation sample of in-house general counsel or other senior corporate litigators asked to rate the states in terms of how reasonable and fair their tort liability systems are perceived by U.S. businesses. Reason four, Series LLC. Presumably, the Series LLC works to segregate and limit liability among each Series LLC if all the LLC's assets and activities occur in the state of formation. The plaintiff is in the state of formation and the lawsuit is filed in the state of formation. If, however, the plaintiff is a tenant injured on property located in California that is owned by the Nevada Series LLC and the lawsuit is in a California court, there is a good chance the California court will apply California law and disregard the series feature of the Nevada LLC. There are no appellate court cases that have ruled that the series LLC limits liability when the plaintiff and the court are outside the state in which the LLC was formed. You may want to be a pioneer and create a new appellate law in your state, but we don't want our clients to hope that the series LLC will work when for a relatively small cost, they can form an additional LLC to hold assets. When you're forming an entity, the first fundamental concept you need to look at is in which state should you form the entity. Most of the time, the answer to that question is in the state that the entity's activities will occur. For example, a person who wants to form an entity to operate a widget sales business in Arizona should form the entity in Arizona unless there is some overriding reason to form in another state, which rarely exists. The second question you must ask yourself when forming a new entity is, what type of entity should I form? Most of the time, the answer to the question is a limited liability company. Form an LLC unless there is a compelling reason to form a different type of entity. So there it is. Basically, steer clear of the concept to form your LLC in Nevada unless you're going to be doing business there. There are several misconceptions behind the idea that it is best to form your LLC in Nevada. So that's it for us, guys. Don't forget to like this video, comment below if you have any questions, and subscribe to our channel for more videos.